Hello, everyone. We will get started soon. We're going to give it a few more minutes for people to join, and so just hang tight. Great. Good afternoon, everyone, and welcome to our members and guests and industry professionals in the Texas hemp industry. This is our Texas Hemp Coalition webinar. Good afternoon, everyone. Sorry, guys, we have Facebook Live going on as well, so I'm making sure that it's all working. So again, thanks to you who are joining us via Zoom and those who are joining us Facebook Live. We're excited to have you. So this is our first webinar that we're doing post the ones that we did a few years ago, and this one will be a legal update over the court cases that have been going on in the state of Texas, which are the smokable hemp ban and the ongoing Delta 8 litigation. So I'm going to introduce both of our guests. They are both executive board members for the Texas Hemp Coalition. First, we have Miss Lisa Pittman of Pittman Legal, who I think everybody knows, which we call her the First Lady of Texas Cannabis. She's been around for a while, really working on, the statute and legislation in and out of Texas. And then also Mr. Cameron Field of Michael Best, who represents a lot of cannabis and hemp groups across the nation and also in the state of Texas. So thank you guys for being with us here today. We're excited to get into it. At the end of this, we are going to be having a question and answer session. So what you'll see, if you're on Facebook, please leave questions in the comments. If you're joining us on Zoom, you can go to the Q&A section. Please ask your questions and we'll filter through those at the end of the presentation and ask those to our guests. So I'm going to turn it over to Mr. Cameron Field with Michael Best.
Thank you. Thanks, Alyssa, and good to be here. So Lisa and I are going to divvy up a little bit. We're going to start with the smokable hemp ban because we just had a decision on that within the last month. And then we're going to go to something that's, I guess, even more pressing, which is going to be the discussion on Delta 8, because that's currently in the court system. So you're going to primarily hear from me at first, and Lisa is going to jump in as well. We're going to just kind of tag team this. We haven't, rehearsed or run through as, smoothly as you want. So we're just taking this live, and we hope everyone's going to be able to walk away knowing more than most people across the state know about these topics by the end of this. So without further ado, I'll jump in here. We're going to start with the smokable hemp ban case, then the Delta 8 case, and we're going to leave some time at the end for questions as well. Alyssa is going to kind of monitor those as we go, so everyone just type in your questions. With the smokable hemp ban case, we're going to break that down further. First, going to talk about, get everyone kind of a base understanding of the laws and the rules that were at issue in the case. Then we're going to talk about the lawsuit, and then kind of our hot takes on the implications of that and what we can see going forward here. So to make sure we all have the same background and we know what was at issue in the case, we're starting with HB 1325, and this is the legislative action that set up what would eventually be challenged in the lawsuit. And this is the prohibition on the processing or manufacturing of a consumable hemp product for smoking. This directed dishes to pass regulations and rules that would effectuate this prohibition. This is what set up eventually what would be challenged in the lawsuit.
I wanted to real quick.
Yeah.
The heading of that, rules related to the sale of consumable hemp products. And the processing ban is under there specified, but it's under a heading contemplating. Yep.
And so what we're going to go through, I don't know if people can see my cursor here, but we're going to talk about processing, manufacturing, what is a consumable hemp product, and smoking. All those things. This is what lawyers do, is we go through and we nitpick, and there's little definitions for every single word. Every single one of these words is important and critical, and that's when you get to litigation with this challenge. Every single one of these is important. And when you're looking at your own business and what you do, looking at what these actual prohibitions are and what these definitions are, have real life implications for the people that are listening in. So process, here's the definition for process from chapter 443. So it means to extract a component of hemp. So we're talking about more extraction here, including cannabidiol or another cannabinoid. So broadly speaking, another cannabinoid here. And that is, as Lisa said, sold as a consumable hemp product. So we're looking at sale here. Offered for sale as a consumable hemp product, incorporated into a consumable hemp product, or intended to be incorporated into a consumable hemp product. And so after you're reading that, you're probably wondering, well, what necessarily is a consumable hemp product? And we'll get to that. But remember, the first two things here are going to be the processing or manufacturing are what's going to be prohibited according to the legislative law. So then manufacturing of a consumable hemp product would be under this definition in 431.002. Some of the language is highlighted that we find most pressing and broad. So for instance, the process of preparing, processing, packaging, repackaging, labeling, the process of preparing, fabricating, processing, packaging. These, according, Lisa and I were talking before this, that looking at the way dishes interprets this language, they interpret it very broadly. So if you're looking at any sort of processing, packaging, repackaging, we're looking at third-party goods, importing bulk items, and then breaking them down into smaller items that you can white label for yourself or for another company. Simply putting stickers or your own labels on the device could be relabeling that product. So it's a really broad definition. And the most important thing is how it's being interpreted by the state government itself, and they're interpreting it broadly for those specific items. I don't know, Lisa, if you have any other specifications of kind of how you've seen dishes look at what this preparing or processing is that you want to share.
Yeah, I've asked, in that situation where someone's not really, quote, manufacturing, they're just putting another label on it or something like that, a different brand name on it. And I've talked to dishes about that, and that's considered a co-packer. So you're both doing things to the package, and that in of itself is considered manufacturing. Basically, I think they look at it as taking anything from the raw stuff on the farm and converting it into a consumable hemp product, a product for sale to people to use.
And so then what is a consumable hemp product? That's going to be any product processed or manufactured for consumption. And below here, we have the definition of what smoking is, and that means burning or igniting a substance and inhaling the smoke or heating a substance. So some people might say, when does hemp become a consumable hemp product? Is inhalation a consumable hemp product? If you just look up the general definition of consumption, one of the first examples provided is regarding the consumption of cigarettes. So I think, yes, consumption through inhalation very clearly does fit these definitions. And we're looking here, it's that smoking very clearly identifies both like vape cartridges, saying the resulting vapor or aerosol, but also smoke or heating of a substance. So looking at products like pre-rolls as well as just flower as well. That's more traditional smoking of the hemp plant. And so these definitions are from dishes. And so you've seen that there's a little bit of a combination of definitions from the legislature and the law that was passed, as well as the regulations from dishes. So then as we discussed earlier, the legislature directed dishes to come up with the regulatory scheme for the regulation of these consumable hemp products and to prohibit the manufacture or processing of hemp products. When dishes put out its regulation, 300.104, they added a couple of things in there, and those are in bold here. And that's also a prohibition on the distribution or retail sale of consumable hemp products for smoking. So that's important to note, that there's a little bit of a difference from what the legislature requested dishes to do and what it ended up doing, that it ended up creating a little bit broader of a prohibition. And this led to a lot of confusion in the industry, a lot of businesses wondering, well, can I even sell these products? When this rule came out, we were getting a lot of questions from retail operations wondering, well, I thought it was just going to be the manufacturer processing. I'm just, importing these goods and then selling them. And we'll get to kind of where we stand now, looking through the case law. So the case that we just had decided at the end of June is Crown Distributing LLC v. Texas Department of State Health Services. It was filed shortly after shortly after this went into effect here, this rule. So August 5th, 2020, a temporary restraining order, also known as a TRO, that was requested to enjoin enforcement of the ban, and that was granted. So at that point in September 2020, that means that the state government could not enforce that prohibition. That stayed in place for a while. The state appealed that ruling. It was affirmed by the Court of Appeals and then sent back to the Travis County Court, where a full trial was held. We got a ruling in November of 2021 where that prohibition was declared unconstitutional in a Travis County court. So at that point, selling, distributing, manufacturing, processing consumable hemp products was still legal in the state of Texas. It was then appealed directly to the state Supreme Court in December of 2021. There were oral arguments in March of 2022, and then we just got a decision June 24th, 2022. And we're going to march through kind of what the legal arguments were. I've got a few more minutes here. What the legal arguments were in that decision and what the implications are going to be. And Lisa and I will kind of go through kind of our interpretation of it. So I put on here the kind of the central component of this case. And this is a portion of the Texas Constitution, Article 1, Section 19. No citizen of this state shall be deprived of life, liberty, property, privileges, or immunities, or in any manner disenfranchised, except by the due course of the law of the land. And that last sentence, that last part of the sentence there, except by the due course of the law of the land. In a lot of different states and in the federal government, this is known as kind of a due process law. In Texas, it's known as due course. And that means that kind of going back to basically the founding fathers of the country, you have certain rights and privileges as a citizen of the country or a citizen of the state of Texas. But if the legislature, through due course of the law of the land, they may limit those rights based on basically what we have as a democracy, and given the rights that we grant to people that are elected and the powers that may be in government. So this was the central part of the challenge here. And to show that the law violated this part of the Constitution, you'd first have to establish that you had a protectable interest under this portion of the Constitution. So you'd have to show that selling smokable, consumable hemp products was an interest and an interest that was provided and protected through the Constitution. If the government removes somebody's right to an interest like that, they have to have a rational connection to a government interest. And if there is not some sort of rational connection, it needs to be extremely burdensome. And those are two different tests and two different thresholds that somebody would have to prove to be able to show that a law was so burdensome and not connected to any interest that the government would have, that it should be ruled unconstitutional. Unfortunately for the industry here, but predictably, the court didn't even get to the question of whether this law was burdensome to the industry beyond government interest, or whether there was even a rational connection to a government interest, because the court found it didn't even get past the first threshold test of finding whether there was actually a right protected by the state here, so the question of whether the state constitution protects an individual's right to sell smokable hemp products, the state said the state constitution does not provide a protection for that. And the legislature is within its rights to restrict an individual's right to do that. So a couple of the takeaways with that is, people just basically, they have rights for employment in the state of Texas generally, but you have a right for what's known as lawful occupations or common jobs or common employment. And when the court looked at whether selling smokable hemp products was something that was like common employment, like being, say, well, we are lawyers, or being a nurse or a waitress, that is something that is more of a common lawful occupation. Looking at the history of hemp and the history of the cannabis plant, for the vast majority and pretty much the entirety of history of the legislature, it's been a prohibited item in the state of Texas since the early 1900s, I believe, is what the case went all the way back to look at how long the legislature had treated or regulated hemp in some regard. Because of the timing of this lawsuit, the plaintiffs had claimed to start selling smokable hemp products before the regulations were in place in Texas. So in between this time where it went federally legal and before the state actually passed certain laws that took it off of the state controlled substance list. So technically the plaintiffs were kind of taking illegal action in some regards, according to the court. And the state said, you don't have a right under the Constitution to do something that is seen as illegal. And even if it was seen as legal, it's been illegal so long and now has had such a small window of a legal marketplace. There's not really anything to show, any kind of like length to argue that you're depriving someone of significant rights by continuing to regulate that substance. And they point to a bunch of different other types of products that are regulated throughout history as well, and how it regulates people's rights, such as regarding casinos or alcohol, bars, gambling, that people don't necessarily have a right to work in those occupations because the state always has the right to regulate those under its police powers. So really, there was a massive uphill battle in the beginning from the plaintiffs. I know it was a kind of a heartbreak for the industry to see this come down, but when you read through the decision itself, it's very sound in law and based in the Constitution of the state of Texas. So some of the quick takeaways here: the right to produce smokable hemp products is not protected by the due course clause of the Texas Constitution. We talked a little bit about that distribution and retail sale portions and whether or not those were included. In the decision from the Texas Supreme Court, the discussion of distribution and retail sale was not included. It was not carried forward from the original Travis County decision. So there's still an injunction in place on the provisions of the law that prohibit distribution and retail sales. So retail operations, if you're wondering, can I sell these products? Yes, technically there is still an injunction in place that allows the legal sale and the legal distribution of smokable hemp products, but there is now a prohibition on those definitions we looked at earlier on the processing and manufacturing of those products. So where is that line for certain people? That's when you end up talking to attorneys like Lisa and I about, if you're in the back room of your retail operation placing stickers on pre-rolls, what does that constitute? If you are obtaining large amounts of flour and breaking it down into smaller ounce jars, what does that count for? Those are all questions that are great to start looking into, talking to an attorney and what your specific problems might be and questions might be. Yeah, so I think that's going to round out basically what I've seen from that. Lisa, if you want to jump in, if you have anything else, I might have one more
I mean,
slide.
just for people to kind of understand why the government did not see this as, a right to do business in this is some of those industries that Cameron mentioned, you have to have a license to do it, just like your driver's license is a privilege, not a right. So they were saying too that, you don't have a right, you may have a privilege, but not a right. And the privilege didn't really even arise until after they put out the regulations where you had to get a license and here's the rules for it and XYZ. So kind of analogous as, when we got marijuana passed in 2015, we didn't even get any regulations until the middle of 2017. So you couldn't set up shop and sell marijuana in 2016. You had to wait until all of the regulations. So there was kind of a difference between it being legal to possess hemp versus whether it was legal to process it and sell it and grow it. I mean, for example, you couldn't grow it till you got your license from the TDA either. So it's a lot of complicated things in here. And like Cam said, it did follow pretty predictably how we would have expected these things to be interpreted, especially by the Supreme Court, which is very conservative and very much going to side on the side of the state, all other things being equal, probably.
Yeah, I think you hit the nail on the head when you said it's a privilege, not a right. I think in the decision they talk about how, what they're prohibiting here is actually, just a segment of a much larger market. They're not prohibiting the hemp industry, period. They're prohibiting just the manufacturing and processing of smokable hemp products. And so
Yeah,
that narrow regulation.
Yeah, they said when something can be taken away just as easily with legislature, then that's a privilege. It's not
Yeah.
not a right. And another thing before we go on that I just thought was interesting that this court did, because it's something that I had never thought about, was they focused on the fact that the hemp for smoking and, as we know it and are using it right now today, is all into flowers, which had traditionally always been considered marijuana and always been illegal. And so they really focused on that part of the cannabis plant when they were evaluating the Controlled Substances Act and what had historically been legal and not legal. So anyway.
Before we move on, we've got some questions. Since we're on the smokable hemp topic, we'll go ahead and get into some of these. And so Lisa and Cameron, if you both could jump in, whoever wants to answer these. So the first one is that this individual says that they understand that you cannot manufacture or process, but can you clarify if cultivation is legal? Because if you can sell it, it just can't be manufactured or processed in the state. And how will this impact cultivators who grow their own bud for smokable hemp products like pre-rolls?
You can grow flower for whatever you want to grow it for. There's no, you don't have to state to the TDA what you're growing it for. So it's what happens after that. And if you are a vertical facility where you then process it into smokable, well, that's where we got to get really strategic and figure out what we're going to do with the manufacturing portion of your operations to keep you compliant with dishes. Yeah, dishes is starting to inspect now, so everybody will be aware. They're out there and they're going to be looking for this too.
Yeah, so I think the important thing is if you're producing or cultivating, you're under TDA, and the second you start moving towards consumable hemp products and things that are going to be sold, that's when you start coming under dishes oversight. And so, yeah, if you're just growing it, you're just growing it essentially until you start getting into the consumable hemp side of things.
Got it. So, and another person that kind of goes on that said, they said, to be clear, we can grow hemp, we can sell smokable hemp. We just can't manufacture smokable hemp, consumable hemp in Texas, correct?
Correct.
Got it. Okay, we have another one. What is the interpretation of manufacturing and processing? I might have missed that part at the beginning of the webinar. Can you just, kind of let us know what that means? And there might have been a lot of people who missed that as well.
Yeah, let me go back to, we'll go back to definitions. So here's the definition of process. Extract a component of hemp, including cannabidiol or another cannabinoids, sold as a consumable hemp product, offered for sale, incorporated. So this is largely looking at the extraction process, but then also manufacturing is much broader. And so this is the hard definition, and then the interpretation is another thing. So that the hard definition is actually fairly broad, looking at the process of preparing, processing, packaging, repackaging, labeling. So this could be looking at, basically breaking things down from larger things into larger products into smaller products for sale, taking one person's label off, putting another person's label on. And it's my understanding that Dishes is also viewing this very broadly from an interpretation standpoint. So the act of putting your own label on pre-rolls, separating a bulk item of pre-rolls into small individual ones and putting your own label on it, that would be also seen as manufacturing. So thinking of a large manufacturing facility isn't what the definition is here. It's more looking at acute actions and the idea of packaging, labeling, those small actions, relabeling of an item. That's going to be what's seen as manufacturing.
And these are definitions that are in the statute. When it says 1325, that's in the law that only the legislature can change next time. And so Dishes, their regulations have to be modeled off of these laws. And one of the questions in the case was, did they go too far on expanding it to retail or not? But anyway, luckily that was as Cam said, that's not what the case went into, just the manufacturing.
Yeah. Thank you, guys. We've got a lot rolling in, so I'm going to get to all these. We have a lot of people asking and talking about loopholes in the process on labeling. So it's kind of a general question is, do you guys see and maybe say that there is a loophole in producing smokable hemp products? And then after that, what labeling can you label their flower? Can someone label their flower as a consumable hemp flower and using it as a loophole so that technically they're not breaking the law?
Yeah, definitely looking at just pure flower. You can sell that without labeling. There's nothing that requires you to label it. Say it's just a jar of flour. There's nothing that requires you to label it as flour for smoking purposes. You could be using it for baking. You could be using it for lighting on fire for incense. You could be feeding it to an animal or any other thing that nobody necessarily needs to know about that's not smoking. And so sometimes discretion is key in terms of not labeling something instead of actively labeling something for its use, or not marketing it for a particular
how you market
use.
Yeah, everything.
It seems like a lot of people have questions about pre-rolls and the labeling of it. So, to clarify, even if the smokable hemp pre-rolls come from out of the state, but if they do put a sticker or a label on it in Texas, does that still violate and constitute it as manufacturing or processing?
I think strictly, if you have a strict look at the statute, I think Dishes would argue that would be manufacturing and prohibited under the law. But that's a great example of, something that doesn't necessarily seem to be like a large manufacturing operation by like the gut, but according to the law, it would be, and where sometimes what would seem as like an innocuous activity may actually be prohibited and illegal. And it gets into what the spirit of the law is and what the actual enforcement is looking like from Dishes. We know that they are out there right now and are enforcing this. And then it also gets into the overall risk profile of the business that's operating. So it's kind of like a question of, if a tree falls in the woods, does anyone hear it? For a long time, FDA wasn't doing a lot of work enforcing consumable hemp products, even though they're federally illegal. there's still a lot of people jumping into the space, and that's largely because they're not really enforcing the law there. We are seeing some enforcement from dishes, and of course, just like with FDA with dishes, the larger a company gets, the more successful you are, the larger target you have on you. So there's also a question that businesses have of how successful they want to be and how vocal and apparent they are in the marketplace, because the more successful you are, if you are skirting the line and trying to make an argument for something that might not be seen that way by dishes, the more likely you are to run into trouble down the road.
And keep in mind that the label has to say manufactured by XYZ city and state. So that needs to not say Texas. So if you're just putting a sticker on from somewhere else, I would have to know more about your specific operation. But if you have a multi-tiered, maybe you can tack it on to the manufacturer you got it from in another state. But these are all client by client, specific analyses we have to make.
And on that, someone did ask that question, is how would dishes be able to tell if a sticker was put on here in Texas or if it was put on somewhere else? And also, do you anticipate that dishes is going to enforce the sale and the distribution portion of the regulations, or, how would you get around the TRO?
Right now, I don't.
Allowing the
Yeah.
sale, right?
Yeah, the TRO is in place, so that is the retail sale is still legal with the injunction being in place, and so there's no need to get around that or anything. That's enforced. That's friendly to the industry right now, through the Travis County courts. But regarding placing stickers, you do have an obligation for consumer packaged goods to truthfully and accurately have labels on, where it's being manufactured, whom it's being manufactured by. And so placing, information on that could be a fraudulent act and could see things much worse, I think, probably than dishes enforcement, which would be product liability claims, which are becoming more and more frequent in the space. So if somebody, purchases a product and sees that it's, manufactured in Austin or, Birmingham or something, but they know it's not from one of those cities, you could then face a claim for an inaccurate label from a plaintiff's law firm, which is going to be much worse than a government official when it comes down to dealing with them.
Yeah, that's for sure. Yeah, I mean, they're testing CBD products across the state, and if your measurements just don't quite add up with the COA, then boom, they can sue you. And so yeah, you've got to be truthful. Also, you got the QR code on your label, so you don't want to try to pull wool over anybody's eyes. So that's why I say it's very case by case basis on your own chain of custody and your business, how you're marketed, where you are, all those kind of factors like Cam listed off.
We're getting a ton of questions, so I'm going to ask a few more because this is what this is for. So we have someone that wanted for you guys to clarify consumable one more time. They were under the interpretation that they could not manufacture or process smokable, but for a tea or tincture, which are consumable, are we saying that they can't manufacture those as well?
Let me get to the slide on that definition. So here's the definition for consumable hemp product. So it's any product processed or manufactured for consumption that contains hemp. And so just look up the definition of consumption. It's quite broad. They say, including, but that's not limiting to food, drug, device, cosmetic, as those are defined by law. So like I said, consumable clearly meets anything that's smoking, because the consumption would be the inhalation portion of it. And what was the other part of the question?
It was over tea or a tincture, and would that be considered illegal if it's for smokable purposes, smoking purposes?
I don't know if I necessarily follow that, but like tea, like a tea that contains hemp would clearly be a consumable hemp product under this definition, because it would be a food. And then a tincture would most likely be qualified as a cosmetic product or like a topical. And so that would also be a consumable hemp product, even if it's not necessarily being ingested, it's still defined by Texas laws, consumable hemp products because it's cosmetic.
Yeah, I think of it as anything you put into your body, whether it's inhaled, absorbed in your skin, eaten. That's my non-legal definition.
Yeah.
Okay. One more question. We have some individuals who are from out of state that are selling in the state of Texas. Some people are selling branded flour to retailers in Texas. So they have QR codes and their flour is compliant. Are their retailers going to be at risk if they are purchasing from an out of state manufacturer?
The law specifically allows the sale of out-of-state products, so long as where those products are coming from, so these out-of-state businesses are compliant with their state hemp programs. And so there's various ways you can talk to us. It depends on the business, but there's ways to make sure you pay for those transactions and have the right COAs and just basically just make sure you have all the agreements in place for that transaction to show, in case somebody starts asking, that those products meet the laws of the state of their origination.
And I don't think this is happening, but technically, if you're selling into a state by e-commerce, for example, you have to be registered with the state with a consumable hemp products license to be selling it. So that would just be another thing to keep in mind if you are using an out-of-state source, if they're doing any retail. I mean, just depending on where y'all sit in the supply chain, you want to make sure your out-of-state supplier is crossing their T's and dotting their I's too.
This would be the same. We have some people asking if they're bringing in like tinctures or gummies, is that allowed as well? And what about, I guess a CHP, are those illegal now too, or is it just smokable CHPs?
Yeah, we're just talking about smoking for the prohibition. So yeah, consumable hemp products, there's still a robust regulatory scheme in Texas that allows for consumable hemp products and the legal sale of those. We're just talking about the smoking of hemp basically here. So vapors, aerosols, flour, pre-rolls, that sort of thing that's marketed as something for smoking.
Great. Okay, we will close questions for smokable right now. I know that we'll continue to get some in, so we'll leave some time at the very end after our Delta 8 segment. And please just continue to put them in the Q&A section and we'll go from there. So Lisa, I will turn it over to you and we will now discuss the Delta 8 issues here in the state of Texas.
We'll try. I mean, this is going to be like a law school class. I mean, the smokable hemp case was easy compared to this. Let me see. There's a little timeline so I can get down to the right one here. Okay. So in the Delta 8 case, here we go. Oh, shoot. Bear with me. I'm sorry. Let me get there. Okay. So in the Delta 8 case, there are a whole lot of findings that need to happen before we get to the result we're hoping for. I'm sorry, I'm having trouble with the PowerPoint. Anyway, I'll figure it out. We'll start with the timeline of events. So in June, we get our hemp law passed in 2019. And then in August 2020, the DEA put out its infamous interim final rule. People had a lot of reactions to that. It even spurred a couple of lawsuits because people thought, hey, this is criminalizing in-process hemp, and the DEA is trying to get involved and all these kind of things. But really, the DEA was just, it was acknowledging that the Farm Bill had happened, and therefore, hemp was removed from the definition of marijuana under the Controlled Substances Act. And so they were conforming their regulations in accordance with the Farm Bill having happened. It's going to be really important to the analysis whether or not that IFR actually made any changes or not. In a way, they did not, but on the other hand, the DEA did specify a few things that they were changing with their own regulations as a result of the Farm Bill. So the Health and Human Service Commissioner of every state can either agree with changes made to the Federal Controlled Substances Act, or they can object to them. So our commissioner objected in September 2020. They had a hearing on it that was placed in the Texas Register in October. Nobody knew about it, so no one was there. In November, there was a memo put out, and I can send you a copy of it, where the Human Services Commissioner objects. He states his two bases for objecting, and I hope I don't mangle these, but one was the definition of marijuana extract, that the new broad definition of hemp, where everything that came from hemp is arguably legal. He took issue with that because marijuana extract is its own term of art. And then also he was objecting to how you can make preparations of with a controlled substance. So like a gummy would be a preparation. It's like pectin and the controlled substance. So the Health and Human Service Commissioner wanted to keep those other things that have other THC isomers illegal marijuana, and the federal Farm Bill, as we know, kind of legalized it all. And so then in January 2021, he publishes in the Texas Register, kind of regurgitates the November memo. And then in March, that's published as final in the Texas Register. It is published as an image of the schedule. So that's kind of a point of contention. Was it sufficient notice to put a picture of the schedules instead of text that you can search? I don't know. That's going to be a question for the court. And then in May 2021, when we were in the legislative session, Steve Paul from Dishes came in and testified that, well, yeah, to the department, this has always been illegal. It's still illegal. And then in 2021, there was an email that went out to a bunch of stakeholders alerting to this fact about the Delta 8. Call Dishes, let them know how you feel. Okay, so Dishes was flooded with calls. And as a result, they put a notice up on their website saying that Delta 8 is still a controlled substance and so forth. So this all got the attention finally of all of the businesses. And so that's when the lawsuit was filed in October 21. They were able to get an injunction in November to allow the sale while this is being determined. And then in the spring, they just had the briefing, and each one is 60 pages, and then there's a reply, and I read all that. Hopefully I'll get it right. But there are a lot of things that need to be considered first. So to get through the analysis. So first thing is, did the commissioner have the authority to make those changes? Well, he is mandated with establishing, modifying, and publishing the schedules. But he can only do that if he is triggered by some event at the federal level of them adding or deleting a substance. So here we go. Was that IFR a triggering event? The law was altered. Was it just conforming and acknowledging a change that had already happened? Or was it really still changing some DEA regulations in response to the Farm Bill? So whether or not he could even object to this plays out for the later analysis, because what procedure he has to follow to change the schedule depends on whether or not he had this trigger or not. The state argues that when there's a tension between the state and federal law, that enough is sufficient. And then, so then it kind of gets to, well, was the objections that he made outside his scope? Was he allowed to make those objections? Or if the IFR was not doing anything, then he shouldn't be allowed to make those objections. Let's see, I'm sorry, I guess I don't have this playing. Try again. Back through. Okay, so then let's, if we get past that analysis. I'm sorry. I think this version is the opposite of the version I have, so I apologize again. I'm just going in circles.
I can jump in with the, I think you might have the last version, Lisa, if you want me to share.
Yeah, I don't think I have the latest version of the PowerPoint. I think that's the problem.
Here, do you want me to jump in and share it?
Put your pictures in, and that way
Okay.
I don't have to keep fumbling through this one. That's all right.
Okay,
Final
so
one has a summary. That's what I wanted to show. Doesn't it have a slide with a summary of all of the 5 things on one slide?
yes. Where is that?
Okay, here we go. This is the slide I've been looking for because that's easier for you. Probably have no idea what I'm talking about when I'm just going off in left field talking about obscure legal stuff. So all these arguments kind of depend on each other. So one of the things that the court has to determine, to back up, the issue in this case is not whether Delta 8's good or bad. The issue is, did the commissioner have the authority to change the definition of THCs? And if he did he follow the proper procedure or not? So the hemp plaintiffs are arguing that he did not follow the proper procedure. And in fact, he didn't even have the authority to do it to begin with because the IFR technically didn't change anything. And so for the court to get there, the court has to find a lot of different things though. And so here are the things I just wanted people to kind of be aware that this is very complicated and that the things that the court's having to decide are issues of procedural law, and some of them pretty obscure. It's not really about whether Delta 8's good or bad. So the court has to decide whether or not the commissioner had the authority to make the changes, which depends on the IFR. Then the court has to decide whether or not the commissioner followed the proper procedures for that. There's a lot of discussion in the case about whether THCs from hemp have always been controlled substances or not, because that's just another factor in the analysis. Kind of like the smokable hemp, where the court was saying, well, these things have been illegal for a long time. This change has only just been made. You don't have a vested right in it yet. And so there's just some little procedural aspects that play into the findings here that depend on, whether or not the court finds that these were controlled substances or not. And then there's a couple of huge issues in this case that also have nothing to do with whether Delta 8 is good or bad or whether or not the procedures were followed. Did the plaintiffs have standing in the first place? In order to have a case decided or to get an injunction, you have to have suffered an injury that the other person caused and that the other person can fix. So the state's going to be arguing that there wasn't an injury because they didn't have a right to do this. The stuff was already illegal. It's always been illegal. And by the way, Dishes is not the right party to fix what you're complaining about because all they do is issue the law. They don't enforce the law. The right defendant needs to be the DPS and the district attorney because they're the ones that enforce the law. So there's that issue. Another huge issue is, does sovereign immunity apply to this lawsuit? So sovereign immunity means that you cannot sue the government or its officials for doing things that are in the course and scope of their duties as the government. So, there is a lot of stuff. Most things you cannot sue the state for, but there are some exceptions. If an official was acting outside the scope of his authority, then a sovereign immunity can be cast aside and they can be sued. So you can kind of start to see how all of these arguments are going to play together because they're arguing that he acted outside of his authority because the IFR didn't change anything and therefore sovereign immunity doesn't apply and other rules apply. So, okay, you can go to the next slide now. So there's the timeline that I already went through. Okay, and so we kind of went through this a little bit. All right, so proper procedures. So I'm just going to do high level at this. If you really want to know the nitty gritty, you should talk to Matt Zorn or Andrea Steele, because they're the ones working on this. But, there's one procedure for altering the schedules, and there's another procedure that the Administrative Procedure Act applies to. And that puts more of a burden on the person making the changes. If the Administrative Procedure Act applies, they have to publish things so many days in advance. They have to take the public comment in the hearing, and so forth and so on. So the state is saying that the Administrative Procedure Act does not apply because he was doing this thing that was in his authority to modify the schedules. But remember, they're arguing that he didn't have the authority to modify the schedule because the IFR didn't change anything. So the court's going to have to go through these arguments, figure out whether it was in his authority, outside of his authority, which rules and commenting procedures apply, and did he follow whichever ones that the court thinks apply. Of course, the state said everything was done properly. The plaintiff said, well, yeah, they put a notice in the register in October, but nobody knew about it. Well, it's not really their job to knock on your door and make sure you're aware of it. I mean, you do have to be paying attention. They pointed out in their brief that if you just searched for controlled substances, it would have come up. I looked for the January posting by typing in tetrahydrocannabinols, and it brought it up. I don't know, the state only has to really do the bare minimum. So we'll see where the court comes down on that. Anyway, so there were good arguments on both sides. So let's go to the next issue. I really do feel like a law school professor here. Okay, so there's a lot of discussion on whether THCs from hemp are controlled substances. So the state's saying, the definition of marijuana extract was unchanged, and that synthetics was also unchanged. There's also a little argument about whether Delta 8 is a synthetic or not. I know we kind of don't really think it is, but there's a synthetic process involved. So is the court going to get that right? I don't know. So the commissioner was, as I mentioned earlier, he was objecting because the broader definition of hemp at the federal level allows all THC isomers and extract preparations to be considered legal. And, that's what we're celebrating every time we get another comment from the DEA or the Ninth Circuit that, oh yeah, Delta 8's legal. Well, that's not what Texas wanted here. So that's why he objected to it. And then the notice that the rule that or decision that he signed in November 21, he pointed out exactly what he was objecting to in the IFR. And again, it's that compound preparation and then the marijuana extract rule. So he changed the definition of THCs to be all THCs are illegal unless it is Delta 9 under 0.3 coming from hemp. Which is sort of the opposite of how we're reading the federal definition. So the state's saying, well, you need to have a narrow construction of the exemption for hemp. And look at how the Compassionate Use Act defines these things. They say that that's support. I didn't totally follow that argument, but they also say you can't ask the court to change a law that's always been that way. And then they focus a lot on marijuana extracts and saying that Delta 8 are illegal synthetics. And I think some of that's to kind of confuse the court and muddy up the waters. I don't even know how necessary it's going to be for them to make all those findings. Okay, so the other huge one, did the plaintiffs even have standing? If they don't have standing because they don't have an injury or it can't be redressed by the defendant, then the court has no jurisdiction over the parties in the case. And so the state is arguing that because there was no jurisdiction to begin with, the trial court made a mistake and that injunction should not even be in place. They're saying, there's no right to do business in a controlled substance, just kind of like the Smokable Hemp case. The Dishes is not the right party. It's got to be law enforcement. And so anyway, that's that argument. I think that's going to be a challenge for them. And then does sovereign immunity apply? And that one's pretty more simple. Did he act outside the scope? If he did, then we can get him on these procedures. If he didn't, well, they're going to have to go back to some other procedures. So the definitions, were changed. You'll note that the original definition, which is on the top, references the federal farm bill, but the modified definition on the bottom for THCs references the Texas law. So one of the things the state was arguing was that when the IFR came out, it put state and federal law at odds because we're viewing it more restrictively than the federal court is. And so you can see that it adds more things there as being THCs than are in the original definition and referencing Texas law. Okay, and then the marijuana extract meaning as well. So, they're making it a lot more narrow. There's only one little exception for a hemp extract here. So I guess the next slide. Okay, yeah, that's about it, I guess. So as you can see, it's a multi-pronged, multi-step analysis that the court's going to have to make here, and it really has nothing to do with Delta 8 or not. It's going to be, does the court make these other threshold findings that then are able to carry them over to the hemp plaintiff's argument here that, okay, he acted outside the scope and he didn't follow the rules. So that's what we're hoping that they'll find, but I'm fascinated to hear what they'll find. What did you think, Cam?
Yeah, I would note that kind of every single one of those questions, there's the pressure is kind of weighted against the plaintiffs here and more in favor of the state. When you look at statistics of plaintiffs challenging decisions by a government, it's rare when a plaintiff can win challenging a governmental decision. There's just so many things stacked against citizens suing a government to try to overcome a decision or a law or a regulation that's put in place. So it is every single one of those things kind of compounds. So if I were putting my money on it, yeah, I would go with the state here. I think it's a very difficult case to win. Of course, I'm a huge hemp advocate here, so we want to be able to see Delta 8 continue and not be prohibited. But there's also silver linings looking at some of the discussions coming forward, specifically looking at that 0.3% Delta 9, that is still something that people are allowing. And I know a lot of the market is moving towards that Delta 9 space as well. So I think all is not necessarily lost for the industry for kind of psychoactive compounds if that does happen.
And regardless of what happens, in January, we're going to be in legislative session again on both of these topics, where it could change again.
Thank you, Lisa, for that lovely law school presentation. I know your law school professors are very proud of you right now. But we're going to get into a few questions here. And again, we'll do the same thing. Please both answer as you see best fit. So we have someone that asks, because this isn't just about Delta 8 being a good or a bad thing, what is the status of Delta 8's legality in Texas, and how does that change or get impacted by the DEA's recent statement of Delta 8 not being a controlled substance?
Okay, well, much like the smokable hemp thing, the ability to sell Delta 8 right now is just hanging by an injunction. So as long as that injunction's in place, then you can continue to sell it. And federal law and state law can be different. There's the Federal Controlled Substances Act, and then every state has its own Controlled Substances Act that might be different from the federal one. So in fact, in most of the states where Delta 8 is considered illegal, it's because the way their Controlled Substances Act defined either marijuana or THCs. I know in the past 6 months or 9 months or so, states have started to specifically outlaw it, but the bulk of them, it was already illegal, kind of under the similar theory that Texas is advancing. But then he changed the definition to just make sure there'd be no question that all THCs, except for this narrow one, are illegal.
And that gets to a little broader question too of beyond Delta 8, but just all THCs except 0.3% on a dry weight basis of the Delta 9 being, so everything other than that being illegal. But also if the language is just focused on, just THCs, there's other cannabinoids that are also available that I think we see more and more people exploring and coming out with new ones all the time. But right now, this is focused on THCs in Texas.
Okay.
But we're seeing different states pass broader laws that are actually more restrictive of this, that look at both THCs, but also basically outlaw or prohibit all cannabinoids that come out of the cannabis plant other than that Delta 9. So, people need to be grateful in some regards, because it's other states are having more restrictions in place than what Texas is trying to do.
So to clarify off of that, at this time in Texas, is Delta 8, is it okay for it to be sold and manufactured in the state of Texas?
Yes.
Okay.
For now.
For now. And then you were also talking about, other cannabinoids where it has to be under that, 0.3 legal limit. So for example, Delta 9, Delta 8, HHC, THCO, those are all okay to sell, whether it's a vape or an edible, correct?
I wouldn't make such a blanket statement, because some of these are so far removed from the original plant that they are synthetics, and then that's another analysis.
Yeah, and I also just wanted to clarify on the prior question, just in case people missed it, the reason why Delta 8 is legal right now is because of an injunction. We don't have a decision like we did in the smokable hemp case. It's still in the court system. Right. So once we get that decision, that will kind of give the gladiator thumbs up, thumbs down on what we're going to have for Delta 8, just so people don't miss that it's in the court system, and it takes a long time to go through.
Yeah, I don't think they have oral argument yet, and they requested oral argument, so there should be one, hopefully. And then we would expect a decision a few months after that.
Yep.
So maybe we've got some time.
So we're also, you bring up the word synthesize, and I've got a few questions in here from people that are stating that, for example, they have a CBG strain of flower that is naturally occurring in Delta 8 in very small minuscules, but they didn't intend to create it. It's a naturally occurring and it's not synthesized. So what about in that type of situation? What type of advice would you give, retailers?
Well, the question, the kind of the definition of controlled substances that we're dealing with, it basically allows for the category of THCs that come out of the plant. It's only specifically allowing Delta 9 in that specific volume or amount of 0.3%. Everything else, so even if it's naturally occurring, would become a controlled substance if this went through from the state. And everything else being all other THCs. So only the tetrahydrocannabinoids, but other items, if it has a little bit of THC in it, that's still a THC.
And so that would also, would it, someone else just asked, would that type of language impact things like HHC and THCO as a synthesized product? So really, the way I read the law, it looks like it's just tetrahydrocannabinols, so just THCs. If it's starting with other acronyms and other cannabinoids that come out of the plant, those haven't been written into the controlled substance definition yet. Do you see it any differently, Lisa? I think it seems pretty straightforward that's how they changed the definition.
Okay, so the IFR, for example, reiterated what we've always known, that synthetics are illegal. Synthetics are usually used by the DEA to mean something that's entirely man-made in a lab, like K2 and spice. So it's not the same as saying, well, you have to synthesize CBD in order to get Delta 8. Okay, that's not saying it's a synthetic, and also Delta 8's in the plant. But when you get further and further removed to the point where you really are just kind of creating something in a lab that doesn't exist at all, is not in any consumable measure, it just gets harder to make that argument that it was legalized under the Farm Bill as a derivative of hemp. It's a derivative, but it just gets harder to make that argument. It's not like that it can't be made. It's just you're more out on a limb the farther away from the plant you go.
Yeah. DEA was very specific that synthesized products need to have an origination in the plant. Or if they're synthesized, they are not originating from the plant. And so if somebody can't really show that chain of custody and command back to, where it was grown and what dirt and what field, what lot, that's where it gets a lot harder to show that it's not a synthesized product. And then it becomes a controlled substance for state purposes, but also for federal purposes.
And would that also, I just got another question, would that also include THCA?
Yeah, I think it would, because it's a THC. And THC, I believe the federal definition, and looking at there's also some bills being floated around that start toying with the definition of total THC and how that's being measured. That's 0.3%, and THCA would be incorporated within that in some sort of formula.
Thank you for clarifying.
Yeah.
Also, we have a couple of people that are asking, when do we think that the court will make an opinion? Do we think that on the Delta 8 case, do we think that'll be prior to our next legislative session?
I bet it'll be before then, because it's, they did the briefing in March or April, and then next comes oral argument, and then a few months after that, so I could see that all happening by the end of the year.
Let's hope so that we can at least, if we'll have, more of a leg to stand on when the legislative sessions comes, so that we kind of know what's going on. We're not.
It's hard for me to say, because I don't know how much of a backlog that they're still on from COVID, maybe
Right.
not anymore.
Okay, we have another question from someone in the state of Texas. They ask, if Delta 8 is extracted from hemp in another state, is it legal in Texas at the moment if they do bring that Delta 8 into Texas to make a consumable D8 product?
Yeah, while the injunction's in place, you can do these things, regardless if it's in state, out of state, whatever.
Yep. And the one question too would be, what is that state's hemp program? If the hemp program for some reason prohibits Delta 8, usually the prohibitions on Delta 8 aren't within hemp programs like the cultivation and production. It's usually within a Controlled Substance Act. So I think even in a state that might prohibit Delta 8, it could be taken from there and moved to Texas, where it's currently legal still, because it would still lawfully be grown under the laws of that hemp program. But there could be an argument from a state that says, well, or from an official or law enforcement that says, that state prohibited Delta 8. And so maybe it's not the hemp laws of that state, but it's possibly illegal in the state of origination because of the Controlled Substance Act of that state. But so just something to note. It could get more complicated.
Also, we have a statement from someone that I think is a good topic of conversation, and something that, a lot of people are probably wondering, is they stated that, total THC is different than Delta 9 THC. Currently, we are held to the 0.9 or 0.3%, and below Delta 9 THC in consumable hemp products. If Texas does make THCs except for Delta 9 illegal, then will that effectively make the flower market illegal as well? Food for thought.
Can you say the last part again?
Right. So would flower then become illegal because the THCs would basically all be affected at that 0.3%?
Yeah, if it contains other THCs other than Delta 9, which it does in many instances, or all instances, that one could say that would be a controlled substance.
Okay.
A lot of that is going to come down to almost beyond lawyers at that point, and go to laboratories and what testing people have, and kind of the science we have to start identifying different types of THCs. And the industry at this point is way ahead of where the state would be in terms of testing products. So that's just something I would throw out there too.
Okay. And then another question is, with smokable hemp, was that effective immediately? And the same with Delta 8, will it go into effect immediately after they make a decision?
Yeah, so right now, like smokable hemp was being held up by an injunction just like this. So an injunction basically melts away the second you get a legal decision. It's pretty much effective the day that it's signed and entered by a court, unless for some reason the court enters an order that phases it in for some reason, but that would be unlikely in these cases.
Yeah, that's one of the things that the state is asking the court to find, is that the injunction was not issued properly because Dishes is not the right defendant, and therefore there was no jurisdiction over the plaintiff, who didn't suffer an injury either. And so they're saying that that injunction should be void because it wasn't proper in the first place. But they didn't address the injunction in the smokable hemp. I guess the retail one is still there, since that's not what was decided. But it is something you have to pay attention to, definitely. All these little legal things.
And I think that's what I hope that everybody has learned today, is we've got two great attorneys on here who obviously understand the law, who are very familiar, that represent a variety of clients. And for those of you out there, the purpose of this is for you to be able to ask questions, to learn what is going on from, the expertise of these two attorneys who have been practicing this type of law in the state of Texas, and to know that both of their services are available for you to use if you do not have an attorney yet. A lot of these questions that you're asking, it's good for you to have one of these individuals in your toolbox so that you can call them, send them an email, send them a text, to make sure that you are compliant as a business, whether that be on smokable hemp, consumable hemp, or, with the Delta 8 issues that are going on. So again, I'm going to give about 5 more minutes for questions. If you have any last minute ones, please put them in the chat. I've got a few I want to go back to on smokable hemp, since that was really popular. So here's one. If flower packaged as a pre-roll is marketed as not intended for smoking instead of marketed as a consumable tea, do you think that would be compliant?
Yeah,
Go ahead.
I was going to say, this is a great point to kind of say a disclaimer that, we don't know necessarily like the backgrounds of everybody's businesses that are asking questions and all the details. So don't take anything that we're saying as, legal advice, because we don't have a client-lawyer relationship. But regarding that specific question, yeah, that gets to the idea and what we talked about earlier of how you market a product. And, if you can market a product as not being smokable, you could also, that's kind of a negative way to market it, is, not for smoking purposes. It's very to the point. You can also positively market it for other purposes that are not smokable, that also would show that it's not intended for smoking. But I think, yeah, that is definitely a little trick many people are going to be using to allow flower to still be sold and purchased.
But again, it depends on your overall marketing. So if you have these pre-rolls that say not for smoking, but they're at a head shop displayed right next to bongs, it's going to be hard for me as your lawyer to argue that that wasn't intended for smoking. So some of the stuff, you got to be able to make a straight face, argument. You just can't put on there not for smoking and you're done,
Yeah, you can't give away some free matches or lighters right next to them.
And I think another question we had a lot of people ask is, what are the consequences if you are, shown that you are selling a smokable hemp product? Are they going as far as revoking licenses?
Well, it starts. Go ahead. You want to go ahead?
No, go ahead, Lisa.
Okay, it starts with a warning, don't do this, then a violation, and then that can come with a fine. And if you still don't obey, then you get a higher fine, and then that's where you can see your license revoked, your business shut down. But I think you're given a little time, especially there's been so much confusion in the law. So I don't think they're gonna come down with the hatchet right away. And it's not a criminal law thing either. It's not like you're going to be taken to jail.
Yeah, that's exactly what I was going to stress, is that we're looking at civil penalties right now. So fines and specific like injunctive relief actions, potentially taking products from off a shelf or something, but no one's going to jail for this.
Well, that's all we have for right now. Again, thank you everyone for participating, and I'm going to leave it to both of you to give some closing remarks before we end the webinar.
Yeah, I would just say feel free to reach out. My email is cffield@michaelbest.com if you have any specific questions. Lisa and I are very friendly. We've shared clients before. We have kind of different areas of expertise within this as well. So I'll let her sign off as well.
Yeah, thank you. You can reach me at lisa@pittman.legal, and would love to help you. I put a lot of things out on LinkedIn too, like a lot of primary sources and things having to do with Texas and the South. So look forward to helping y'all any way I can.
Well, again, thank you so much for both being here. We have Mr. Cameron Field of Michael Best and Miss Lisa Pittman of Pittman Legal. You can find them both on our website. If you go to texashempcoalition.org, you can click on their picture and it'll link to both of their websites and how to get in contact with them if you're looking for an attorney. We have a lot of issues like this that are coming up. Our goal is to have a webinar series every other month. And something really exciting that we are wanting to share with everyone, I'm going to share my screen now, is I'm sure everyone has seen the Texas Hemp Summit that we have coming up. Let me share it real quick. We have the Texas Hemp Summit that will be coming up this fall. We unfortunately had to postpone in June, but everybody has summer plans. So we have our new dates that we have chosen. So the Texas Hemp Summit will be held at Texas A&M University on November 11th and 12th of this fall. It will actually be held at Texas A&M's AgriLife Center. It's a very, very beautiful building, which is connected to the College of Agriculture and the AgriLife Institute at Texas A&M University. We hope that everyone attends. We will be selling tickets starting on August 1st. Again, if anyone is interested in attending, if you're interested in sponsoring our event, or you might be interested in being a panelist or a speaker, please let us know. Contact us via our website or through any of our social media channels as well. You can go to texashempcoalition.org/summit for all information to see who we will have speaking. We've already confirmed that Commissioner Sid Miller will be there, which will be wonderful to have him in person. We'll have individuals like Dr. Jessup of Texas A&M University to talk about the research that they're doing. We'll have a fireside chat with Cameron and Lisa talking more legal issues, and we'll have experts from the state of Texas and most importantly from beyond, because we want to bring experts in from out of the state who have been growing this plant, who have been manufacturing and processing it for quite longer than we have in the state of Texas. We're still new. So again, we would love to have you there. This is a business to business, so it's open to people involved in the hemp industry, those looking to be involved, or just those that are interested. And most importantly, it's free to students. So you just have to show us your student ID and you come in for free. So it'll be held from 9 p.m. to 5 p.m. on that Friday and Saturday. So we hope to see you all there. Check our social media accounts. And as well, if you haven't signed up to be a member of the Texas Hemp Coalition, you can go to our website and join. We have a business membership, a farmer membership. Next webinar.
Thanks, Alyssa. And thanks to the Texas Hemp Coalition for putting great things like this together.
Yep. Thank you.
Thank you, guys.
Bye-bye.